Good morning, everyone. Good morning, and a very, very warm welcome to all our new subscribers and old. Thank you so much for joining our Women in Sectional Title webinar. This is definitely the place to be if you're a rental agent, a managing agent, an owner, a trustee, or just anyone who's interested in this community scheme space. I think it would be really helpful if you looked at our website, www.womeninsectionaltitle.co.za. You can have a look at our webinars. We've been giving webinars at least once a month for the last almost 2 years. So you're sure to find something interesting. I think of particular interest would be our webinar from last month, where we showcased all our sponsors to show what their services are. And I think that that would be a place to go. So if it wasn't for our sponsors, we would be lost and certainly wouldn't be able to transmit this platform. So thank you very much to ZFIN, CIA, We Connect You, Sectional Title Solutions, and PKF Octagon. You guys are awesome. So today we're talking about dealing with tenants in the sectional title industry. And I am so privileged and proud to be able to introduce my friend and colleague, Marlon Shevelew. Marlon is the director of Marlon Shevelew and Associates, and I'll tell you a lot more about him as the time goes on. Welcome, Marlon.
Thanks, Marina. Thanks so much for having me, for extending the invitation. And I'm thrilled to see such a wonderful amount of people who are tuning in to empower themselves, especially the women in sectional title. So thank you, Marina.
Thank you. I think you can add to a couple of your accolades. You could add Smile Maker, because you certainly keep me entertained with your Facebook posts. All human, lighthearted, and I really appreciate that. I think this is such a serious topic. Sometimes we need that kind of energy. So well done for that.
My pleasure.
Marlon, talk us through what your firm is doing and what you are doing currently in the rental space.
Of course. Thanks, Marina. So Marlon Shevelew and Associates is now in its 18th year, and about 20 years ago when I started practice, I saw there was a gap in the market to make a focus on rental property law. And even now, I still feel that a lot of rental agents, rental property practitioners, as you would call them, are maligned, because I don't believe the PPRA is doing enough in terms of CPD and training to actually educate and empower rental property practitioners. So along with the traditional litigation work of suing non-paying tenants, evicting non-paying tenants, we also have an advisory service through the Rental Retainer Club. So we've got different companies that focus on letters of demand, and then we focus on the advisory services through the Rental Retainer Club, and then through Marlon Shevelew and Associates, which is the predominant governing law firm. We do a lot of eviction work and rent collection work, which sounds somewhat terrible, somewhat parasitic, because we effectively are depriving occupiers of their right to stay somewhere, be it in a residential property, a freestanding, or in a complex, and as well as suing them for money owing. But we don't just represent landlords, we also represent tenants. It depends who's putting the money in our bank account. So ultimately, the rental arena is quite dichotomous, because freestanding, in complexes, the community schemes have now changed. So we find there's quite an anomalous situation where we are evicting tenants from, as I mentioned, freestanding or in complexes or homeowners associations. We're indiscriminate about who we are acting against or acting for. But I just think it's a really interesting space, because if you think of a property lawyer, and you correct me if I'm wrong, you think, oh, well, my attorney, he's a conveyancer. Conveyancers can only, in my opinion, transfer properties, or preferably transfer properties with free and vacant occupation. And that's where we fit in. We try and ensure that there is free and vacant occupation available to the purchaser of the property.
And Marlon, what are the trends in this arena with the arrears? I mean, I probably know the answer if you look at the socioeconomic situation in the country, but you tell us. I mean, you're at the coalface in terms of dealing with these numbers.
No, absolutely. And it would be quite a jaundiced view on my part to tell you about the trends, because we don't really see many nice tenants. And as I say, we are actually currently evicting, and I know it sounds unbelievable, but we're doing at least 40 residential evictions a month. And that is notwithstanding the commercial evictions that we do for listed companies. Now, it sounds like a lot, but because we are on retainer with a number of rental agencies, 40 isn't actually a lot if you look relatively speaking. But the short answer is that what we are seeing is that there are a lot of non-paying tenants. And I think the trends have basically carried on from COVID. I don't believe people have caught up. People are still struggling to catch up and pay. People have lost their jobs. You know, the economy is unfortunately, with the rise in interest rates, the economy is quite unforgiving. So we are seeing a lot of tenants who are still struggling to pay. We're seeing tenants who are being quite obstinate in sectional title complexes and in freestanding houses. And we're seeing a very, very interesting turn of events with regard to landlords, because on the one hand, you've got landlords who are sympathetic, who will allow and indulge tenants to pay late, who will pick up the slack, so to speak. And then we've got landlords who are absolutely merciless, who have tenants who have been there for years and years and years, and who are indiscriminate and tell us to evict them and throw them out legally, of course. So we are seeing a lot more people moving into gated complexes, absolutely, a lot of security, but we are also seeing a lot of landlords trying to take advantage of the whole Airbnb, short-term letting, make income quick, being mindful of the fact that, of course, the body corporate always has the power to change that rule. So yeah, that's what the trends. I don't know if they're really statistical trends as such, but based as an attorney in the rental arena, that's what we are seeing.
I'd like to move on to the actual eviction process. Before we discuss I want to also discuss the community scheme ombud service. But first of all, in a sectional title complex now, let's just zone in onto the scenario where you have a body corporate who's dealing with a tenant who's difficult, or, you know, we've always said you can't, as a body corporate, you cannot evict a tenant. That was one of my first questions that I was asked as a sectional title attorney. So just clarify for us, it's the owner has the legal relationship with the tenant, correct?
Yes, absolutely. The PI Act is quite specific, because the PI Act says any owner or person in charge of their property. It's again, this is where I find a particular interest in this topic, because you've got sectional title agents who manage the complex, for want of a better word, and then you've got rental agents who manage individual units in the complex as well. So you've got a lot of role players. If you look at the sectional title industry, you've got trustees and you've got owners, and you've got managing agents. But if you take it a little bit further, you've also got landlords and you've got tenants. Now, you don't have to be an owner to be a landlord. And I think when we see the sectional, at least the Rental Housing Amendment Act of 2014, eventually becoming law, they're not going to be called landlords anymore. They're going to be called landowners, which is quite curious, because as I just mentioned, you don't have to own the land to be a landlord. So it's a very interesting aspect. And the PI Act is quite clear. You know, there has to be, and an unlawful occupier doesn't always have to be a tenant that doesn't pay. Anyone who takes over a property without the approval of the owner can be evicted. But the PI Act is quite clear, and it says it is between either an owner of a property or a person in charge of the property. The body corporate has no jurisdiction over a tenant per se, because there is no legal relationship between the body corporate and the tenant. The body corporate's relationship is with the landlord. The landlord relationship is with the tenant. So that's why the PI Act can only be brought by a person who has what we call the locus standi to bring that application.
And just tell the listeners, what is the PI Act an acronym for?
Of course, the PI Act is the Prevention of Illegal Eviction from and Unlawful Occupation of Land Act. It came about in 1998. It is the only legal way in South Africa to evict somebody from a residential property, be it a residential unit in a complex or a freestanding property. And any attempt to extricate somebody from a property without following that procedure can be met with huge punitive consequences. In fact, it's quite ironic that it may take at least 3 months to lawfully evict somebody if you look at the specific time periods, which can't be varied. They are what they are, and they're probably more problematic now because of the backlog at COVID. But in the event that you choose to unlawfully deprive somebody of their right of occupation, changing the locks on the door, depriving them of electricity, whatever the case might be, in respect of non-paid rental, they can approach the court or the tribunal on the same day and force you to put them back into the property at your cost. You eventually will have to pick up the legal fees for having them to do that. And the courts and the tribunals will not care if that tenant owes R1 million. They simply want to know, were they in peaceful and undisturbed possession? So the PI Act came about actually in 1998, and it replaced the Prevention of Illegal Squatters Act, which came about in 1951. So the courts actually frown upon the use of the word squatters, although it is still thrown around, and squatters basically are deemed to be tenants who are leasing, the lease is cancelled and they don't leave, or somebody who moves into your property without any approval or consent of the owner or the person in charge. So the PI Act, when somebody says, please evict my tenant, they need to know it is a tedious process. It is based on Section 26 of the Constitution. And if your attorney doesn't specialize in it, it could cost you a lot more in terms of delays, in terms of loss of income, and particularly in a sectional title complex, in a community scheme, a depreciation in the value of your property. Because I can assure you, any unlawful occupier that occupies your property unlawfully is certainly not going to do any maintenance in the property or seek to maintain their property for your benefit.
No, that's for sure. So, I think when, a couple of years ago, people were starting to say, oh, well, don't get a tenant because it's too difficult. You can't get rid of tenants nowadays. It's impossible. So that's what the layperson's attitude was. And I mean, it is difficult. And I know certainly the paperwork is thicker and your applications have got to be precise and you've got other things to consider, like where that person might go. We can talk through that. But it's not impossible to evict tenants.
No, not at all. In fact, the eviction starts long before you actually draft court papers. It starts with the letter of demand and the nature of the demand, because if it's a natural person or a juristic entity, the time periods are different, 7 calendar days or 20 business days. And if that is followed correctly and the letter of the law is followed correctly and the lease is formally cancelled, inevitably you will get your eviction order. The only downside is the amount of time that it takes for a judicial officer to actually give you that court order, because minorities, heads of household, people who are disabled, there's a lot of factors. And now alternative accommodation. In fact, the issue of alternative accommodation is currently pending before the Constitutional Court from a case of Bromwell, which is the Woodstock eviction. It's a very, very famous case where the city of Cape Town now is opposing it, and they're looking to change the laws whereby if somebody is evicted and rendered homeless, that the city must provide alternative accommodation, even if it's a private residence. The reason why I know this is because I personally, through my firm, obtained the eviction order against 20-odd families. They weren't particularly odd, but 20-odd families several years ago, and we're now going all the way to the Constitutional Court. So it's not impossible, it's just difficult. And there are lots of tricks, if you want. I mean, I don't want to give away all my intellectual property, but for example, a lot of people do evictions through the magistrate's court. Very well, it's in the jurisdiction where the property is situated, not realizing that any eviction you obtain in the magistrate's court can be automatically appealed. Whereas if you go through the High Court, there is no automatic right to appeal. You have to ask the judge that ruled against you to give you the right to appeal. So we prefer the High Court for that reason and because of gravitas. And I'm happy to say we've never lost an eviction, and I've been doing it for 20 years. It's just a question of how much time it takes. So there's lots of ways of dealing with it, but if you are going to do an eviction, you need to make sure that you dot your I's and you cross your T's. Before the lease is even signed, you need to be fatalistic and say, what's going to happen when it gets to an eviction? And also not to belabor the issue, but even who you're putting into the property. If you're putting a single person in, it might be easier to get them out. If it's a family with children, you might have more difficulty because you have to displace them and where they're going to go. And on top of that, if you go back to the sectional title arena, what's the personality of the block? You can't be discriminatory, absolutely not. But who are you putting into the unit? Who are you putting into the block? And what's the history of the block? What's the history of the tenants that have occupied it? Do your screening. Due diligence cannot be underestimated. So eviction may be difficult, but it is amplified in difficulty if you haven't done your due diligence before you put that tenant in the property.
Absolutely. And now the rental tribunal, the rental housing tribunal, where does that fit in?
The Rental Housing Tribunal is an amazing institution for a very simple reason, that it's about accessibility to the public. It's affordable. In other words, it's free. They don't encourage attorneys to come there. You're welcome to bring an attorney. I mean, we argue in the tribunal every now and then, but it's cost ineffective because invariably you have to pay your attorney, but you won't be able to get those legal fees back if you win your case. And ultimately, it arises from unfair rental practices. So, for example, if the landlord doesn't do his maintenance of the property, or if the landlord tries to force the tenant out without following due process, or if the landlord tries to, deprive the tenant of water or utilities, or if the landlord simply rocks up there without giving reasonable notice. But similarly, the landlord can take the tenant to the tribunal as well if the tenant doesn't pay the rental on time, or the tenant doesn't want to remedy any damages that he's caused to the property. So it's a lovely avenue, but conversely, the big downside, there are two massive downsides. In fact, probably a lot more. The one downside is that they have no jurisdiction to do evictions. So you can't get a tenant out of a residential property through the Rental Housing Tribunal. And of course, the Rental Housing Tribunal is different in various provinces. There's a national set of unfair practice regulations which will be promulgated in terms of the Rental Housing Act, but that isn't law yet, and nor is the Rental Housing Amendment Act. So all we have is a fraction of availability of the true regulations because it's scattered amongst different provinces. But what's great is that if you're a tenant and you don't have money, you can apply to the Rental Housing Tribunal. The landlord will get a letter. The landlord will be told you can't evict this person for 3 months until we make a decision on what happens. And they offer mediation services. They offer arbitration services. And ultimately, if none of that works out, they offer a hearing where you go to a tribunal, an informal court, and you argue your case. So the first thing is affordability, which is great. The problem is no authority to do evictions. The other problem is, and it's something which is being addressed when the Rental Housing Amendment Act of 2014 eventually it becomes law, please God, before 10 years have passed, is that you can't appeal the tribunal decision. You can only take it on review. So if you lose in the tribunal, you can't say, well, the merits weren't considered correctly. All you can do is say, well, procedurally, you didn't apply your mind correctly, or you didn't follow the law correctly. So procedurally, it is a problem because it's not a review, it's not an appeal per se, and a review can only go through the High Court. So you're trying to save money by going to the tribunal, but in the event that you want to challenge a decision, you've got to go to the High Court, which means an attorney and an advocate. And
similar to the community scheme ombud service, yeah.
Correct. But also, just one more thing, Marina, not to interpose, but also the tribunal, when they make a ruling, it's actually deemed to be an order of a magistrate's court. So where the dichotomy comes in is that Section 13 of the Rental Housing Act says any ruling made by a tribunal is an order of court, an order of a magistrate's court. And order of a magistrate's court automatically, in terms of a magistrate's court, would be appealable. But this particular order of a magistrate's court is not appealable because that function is not available in the tribunal. So there's lots of things that I have issues with in the tribunal, but I can assure you right now, I've never been dissatisfied with the results, but also it carries no precedential value. So you can't say, well, Marlon, my friend won in the tribunal and he got 2 months reasonable cancellation penalty, even though the lease was terminated belatedly or whatever. And I said, well, it doesn't really matter because I can't use that as a precedent. Whereas in the High Court, potentially you can use that as a precedent. Even in Magistrates Court, you can't use that as a precedent. So lots of different things that come out of it.
So talk to me now about timelines. In your world, your firm, when you go and you try, now I know this is a difficult question to answer, and we won't hold you to it, although this is being recorded. Just tell us, what kind of time periods? Everyone's dying to know, how long does it take to actually evict a tenant?
If it's unopposed, it can take about 3 months. But the problem is that normally we would apply for a court date. We would calculate, well, we are going to court to get the right, because it's incredible. You've got to actually approach court to be given the right to serve those court papers. It's incredible. So we can't just, for a rent interdict summons, for example, tenant owes money, we draft a summons, we take it to the clerk of the court stamps it, we drop it off the sheriff will serve it pretty soon, I hope, and then there's 10 days to defend it, etc. For an eviction application, we draft the application, we have to pick a date. We have to actually wait for the allocation of the date. Since COVID, the court has to say, Mr. Shevelew, here is a date for you. That date is just to appear in court, in open court, for the judge to look at the papers to say, right, Mr. Shevelew, you now have the authority to go and serve those papers. We can't have a sheriff serve an eviction application until a judge has given oversight of those papers. And once it's served, of course, there is, mandatory 14 court days where the tenants or the unlawful occupiers at that stage, because you can't evict a tenant, you can only evict an unlawful occupier, has 14 days to defend it or oppose it. And if they oppose it, that kicks it onto potentially an opposed role. And ultimately, it can take 6, 7, 8, 9 months. If it all goes smoothly, it should take about 3 months. But, you know, it's, as I say, the problem is now, it's bureaucracy. There are far less matters on the court roll. And we are more concerned, not so much about the time that it takes to get the eviction order, but what happens in the interim. So again, to let you in on another slight trade secret, if an eviction is opposed in the High Court, what we might turn around and say, listen, Mr. Tenant, Mr. Unlawful Occupier, why don't we do an agreement of settlement whereby we give you 3 months to vacate? We take that agreement, we make it an order of court, and it's a done deal. And we've got very angry landlords saying, but Marlon, they haven't paid me for 6 months, and you know, now you give them another 3 months. And I say to them, well, let me give you the alternative. We wait for the matter to come on the opposed roll. They file an answering affidavit. Then they file heads of argument, and then they want to bring application for leave to appeal. And next thing we're hitting June 2024, and they're still not out. If they sign a settlement agreement, be it the magistrate's court or the High Court, is not appealable. That's where the secret comes in. So we have ways and means of finding ways to facilitate it, because we are saying to the landlord, let them leave in 3 months' time, because if they leave in a year's time, you can't mitigate your loss. You can't put a new tenant in. Property valuation, possible problems with the whole body corporate, because you've got a non-paying tenant who's causing a ruckus and he can't be told to leave until there's an eviction order in place. So you've got to think laterally for the greater good, especially in a body corporate, because non-payment of rental and an eviction is localized to the landlord-tenant relationship. But when it goes beyond that, it impacts the potential substratum of the entire community scheme. So you need to think laterally, Marina.
Exactly. And I like that practical approach. I think it's important for us as attorneys to always give those kind of options, because just, you know, going down the same path, getting the same documents, churning things out, I think those days are long gone. So yeah, that's great. Excellent. What about rental agents managing sectional title properties? I know that we had a recent case where the rental agent was tasked with doing everything, even paying over the rental as the levy to the body corporate. And then that particular rental agent really was almost, well, is at the point of being convicted now for fraudulent activities, didn't pay over the levies to the body corporate. I mean, is it dangerous to put all your eggs in one basket with a rental agent?
Look, I love rental agents. It's easy to say that because they're my bread and butter, and I represent several hundred agencies. I'm a retainer with several hundred agencies through the Rental Retainer Club. There are a few fly-by-nights. There are a few that lack legitimacy, but I can tell you right now, they certainly have a role to play. And between you and me, a rental agent being able to act for you, especially in the sense of procuring a tenant, overseeing payment of levies, rates, taxes, incoming inspections, outgoing inspections, it's an absolute luxury to have a rental agent, because invariably you're giving up a portion of your monthly income. But the converse argument would be to do it all yourself. It doesn't make sense. Now, a rental agent, of course, in terms of their mandate with the landlord, has a job to do, and depends on the scope of the mandate. It doesn't have to be a generic document. But I can tell you right now, the fact that you instill the authority in the rental agent to pay levies, for example, to the body corporate, and the rental agent doesn't do so, it doesn't detract from the fact that you are still liable to pay the body corporate. The body corporate doesn't have to abide with the relationship or the arrangement between the landlord and the rental agent. Legislation says pay your levies. The fact that you're using a conduit to do it for you and they don't pay is inconsequential. The body corporate has every right to proceed against the owner and say, hey, us, I don't care that you pay the rental agent. You've got a problem with your agent, sue the agent delictually for the damages you've suffered. So I do believe rental agents have a role to play. The only thing that I find somewhat anomalous is that you've got rental agents of individual units, and then you've got managing agents of a complex. And sometimes they don't always meet eye to eye, because you've got your scheme rules, you've got your conduct rules, and you've got an obligation of owners of units to make sure that the rules form part of the lease agreement. We all know that, Section 5(8) of the Rental Housing Act. And then you've got a perception sometimes, and maybe I'm wrong, of sectional title complexes or body corporates and trustees and managing agents who don't believe that either rental agents or landlords are giving enough gravitas to the nature of the tenant being put in the property, especially if it's an owner that doesn't live there. So as I said, there are quite a few situations that arise. And I just think that rental agents have their place as long as they've got their FFC, they know what they're doing, and that the placement of tenants in units, in sectional title complexes is done simultaneously with acknowledging the personality of the block. Who's there, who's the tenant, screening and making sure that they are read the right act and understand the veracity of what exactly it means to stay in a complex.
Yes, I see there's a question from Magda, and it's a very good question. Sometimes the owner doesn't pay the levies in the sectional title scheme. And what happens is the tenant is then cut off or disconnected, the electricity is disconnected. Just for everybody out there, you're not allowed, the body corporate is not allowed to disconnect electricity or water services unless there's a court order. And most recently, we're getting court orders quite easily at the moment, but there has to be a court order to disconnect electricity. They can't just go ahead and do that by themselves. So, Marlon, just also, there's often been a bit of confusion with the community scheme ombud service and maybe the rental tribunal. I just want to put it out there as well.
Sure.
So with the community scheme ombud service, now tenants are actually able to approach the community scheme ombud service if they have a dispute with the owner and vice versa. But most recently, I think you'll find this interesting. I was in a legal discussion with the legal department of CSOS in looking at amending the rules. And one of those alternative dispute resolution rules was saying that the community scheme ombud could get involved in granting orders around rental. And we pointed out to them and we said, no, that's not the case. It has to be rental tribunal. So I think, have you faced any sort of confusion with tenants about CSOS?
I can tell you now that it's usually owners, of course. I don't see how CSOS has any jurisdiction to deal with rental arrears in particular, or rentals, because that emanates pursuant to a contractual arrangement between a landlord and a tenant. So I don't think CSOS has a role to play there. But ironically, Section 38 of the CSOS, of the Act, of the Community Service Ombud Act, is so wide that it actually allows for disputes and tenants to approach the ombud. I think the tenant would be very hard pressed to try and get some relief from an ombud vis-a-vis issues arising out of the lease agreement. But let's take that a little bit further, because we all know that non-paying tenants obviously impacts the landlord. That's a tribunal issue. It's an unfair rental practice on the tenant's part, but they might say, well, you haven't maintained the property, therefore I'm setting off the rental. That in itself is interesting because your lease agreement says you can't set off rental, no deduction, no set off, despite anything. And yet the Consumer Protection Act says it might be an unfair, unreasonable, unjust term to not allow set off. But the big thing about the community schemes is that the conduct rules must be attached to the lease agreement, which means there's an incorporation by reference of the rules that govern the body corporate forming part of the lease agreement. And I love that because it allows a landlord to rely on breaches of the conduct rules to be a right to cancel the lease. So I do think there's a role to play with the community scheme in the sense of it's so wide. But I do think that if it is a rental arrears matter or an unfair rental practice or a lack of maintenance or something, or an unlawful eviction, the tribunal is possessed of that authority to deal with it. But if it is something that potentially goes beyond the norm of a landlord-tenant relationship, which is potentially impacting the complex. So, for example, loud music. Loud music is a breach of the rental agreement because it might be a breach of the conduct rules, but it's impacting other people where other good tenants who are paying their rental or owners are unhappy and are unable to enjoy their property. You might find that there's legal causation there to approach the community scheme ombud to make a ruling against the owner of that property where the problematic tenant is. But offhand, to be so verbose, I've never had a situation where a tenant has raised issue about a lease matter and threatened to go to CSOS. I've yet to see that. Maybe it'll come soon.
I saw a question that came up from Larry, also an interesting one, which said that can you sort of soft lock the prepaid electricity of an owner, you know, if the tenant hasn't paid the rental? The answer is definitely no. You can't do that. Yeah, absolutely not. So would you agree, Marlon?
I would agree. You know, I know it's a big point, especially with prepaid meters. I've had the argument that, well, when it comes to meters, if the tenant doesn't pay, or alternatively they do pay for the meter, a portion gets allocated towards outstanding rental. I mean, if you look at municipality, if you owe money on your rates, and we do quite a bit of work for the city of Cape Town, if you don't pay your rates, whenever you buy electricity on your prepaid meter, we know a portion gets allocated. But that is the service provider. The municipality provides the services. You don't provide those services to a third party. So if you do act in a way which deprives an occupant or a tenant or an owner of their right to electricity, it could be an act of spoliation, would it not? It's just something that is not allowed.
Yes, absolutely. And I might pause just to mention here as well that the same applies when an owner owes levies. We've had a few managing agents who've tried to also stop the prepaid meters and say, well, we load all the arrears onto the prepaid meter and you have to pay that before you can, you can get your electricity. The community scheme ombud is very clear about that. You are not entitled to do that at all, if anybody's watching and was wondering. Marlon, would you say that tenants get a bad rap? I mean, a couple of weeks ago, we were at a complex in the northern suburbs and we were looking at a lot of maintenance issues. The complex is looking quite shabby. And one of the comments that was made was, well, there are a lot of tenants here. There are not a lot of owners and they don't look after this and they don't look after that. Is that true to say? I mean, it's a bit of a general statement.
As I said, we only see bad tenants, unfortunately. I wish we could say we saw a lot of good tenants, but that really wouldn't pay the rent. I do think tenants do get a bad rap. I think what is missing here is that a lot of landlords, not a lot, but a few of them are bad eggs, in truth. They are disinterested landlords who are willing to just put any tenant in as long as they pay their rental. So I do think some tenants get a bad rap. And the truth of the matter is, Marina, is that the kind of tenants that are put into freestanding or sectional title complexes, if they are vetted correctly and due diligence done to the best of your ability, there shouldn't be problems. The big problem, however, is there isn't proper due diligence done, or alternatively, landlords or rental agents don't truly record the bad data on the appropriate systems. So I see bad tenants all the time, but I can assure you, in as much as I see a bad tenant in the terms of a tenant who can't pay, or who doesn't pay rental, and who says, sue me or evict me, I know the rules, I see tenants who are unable to pay. I see tenants who are trying to engage their landlords to indulge them. And I see landlords who are incredibly sympathetic, and then landlords who are absolutely abhorrent and say, Marlon, evict them. Obviously, we wear whatever hat we have to. We're quite immunized to the whole situation. But I think it would be remiss of me to say that all tenants are bad. I think there are bad landlords, bad tenants, bad trustees, bad attorneys. So, yeah, each to their own.
You mentioned the word vetted, and I find that quite interesting because also at the very beginning of my career, all these chairmen were phoning me and saying, look, we've set up an interview with the tenants of the owners who want to bring in tenants. We'd like to just see what type of person comes into this complex because they might not be our type of person. And I mean, obviously we had to say to them, well, that's a bit ridiculous. You as the chairman of a body corporate or the trustees of a body corporate can't vet tenants. And I think that's something that I don't know, have you seen anything like that with tenants, or you're not really involved with that side of it?
Look, I'm not really involved in that side of it, but I can tell you, you've got to tread very carefully as to not allowing certain tenants in based on whatever description there is. I'm of the belief, though, that certain tenants, for example, if again maybe there's an issue here because you've got the equality court and you can't discriminate, but if it's, for example, a university estate where students live there and an elderly person comes there, would it be the right place for them? Or alternatively, it's a young student moving into a fractional development. So the question is, I think it's important for the body corporate and for the chairman to be mindful of which tenants are moving in, because they've got a vested interest in it. Don't forget, I mean, you would know that tenants have access to common areas. So depending on who the tenant is, I'm not saying you can discriminate who comes in there, but I think there should be oversight. And in as much as it's a duty of an owner to ensure that the tenant complies with the body corporate rules and the contract rules, I think there should be some oversight and something inscribed into the rules that provides that the chairman, or at least the trustees, have a right to assess the veracity of the tenant. I mean, that's just my view. It's not a freestanding property. There are many tenants, there are many owners. And I think whoever is in there, it could have implications on the conduct of the whole body corporate. I don't know what you think, Marina. I just think it's something that should be entertained.
Yeah, it's difficult, but if you've met some of the chairmen I've met, then you might change your mind on that particular issue. Not sure. So in your opinion, what would, if you had to ask me, what are the three of the greatest issues you encounter with rentals, and some advice on how to deal with them?
Well, I think the big thing is defaulting tenants, obviously, especially in the rental arena, be it freestanding or sectional title. Tenants who default and they don't pay, and I think that's a big one because, you know, there's a contractual obligation. The landlord says, here's a place where you can live. I'm paying the levies in a sectional title complex. Please pay your rental and I'll give you the right to enjoy your property. So defaulting tenants, of course. But two other things which I see, which might be not as common as one thinks, is the first one is landlords who are too robust. So tenants who don't pay and the landlord says, sue them, evict them, not realizing that it's a process. Not realizing that, you know, you can get a lot more with what's it, honey, as opposed to, I don't know, what's the analogy? It's if you engage somebody to say, right, I'm gonna give you time to pay off. I don't want you to leave. I want you to sort yourself out. I think a lot can be done by enticing them and negotiating with them and indulging them, always being mindful that just because you indulge them doesn't mean you waive your rights to take action. But throwing somebody out and suing them for money owing costs money. The money that you pay your lawyer, you'll never be able to recover in full because no court will award you the costs that you've had to pay your own attorney. During that time, they won't pay. They won't look after the property. And on top of that, once they do leave, the cost to repair the property, to find a new tenant, and all the costs and the loss of income together might not make it worthwhile. So don't be too robust. And I think landlords should be mindful of that. But the last thing, which I really would love to just impress upon those who are listening, is that lots of rental agents don't know the law. And rental agents will communicate with tenants and say, you can pay late, or you can do this, or the lease comes to an end and they stay on and you send a rental invoice and you create tacit relocation, or, for example, your indulgences are not recorded in writing and the tenant says, well, you let me pay late, and you set a precedent. I think rental agents, not sectional title agents per se, because the legislation is quite strong, but I don't think the rental legislation is strong enough to actually educate landlords and rental agents. I think rental agents need to have an attorney on board, without dropping my own name here, to understand, because the minute a rental agent starts communicating with a tenant and tells them certain things, they need to know that what they're telling them is correct. When they report to their landlords about a situation, they need to know what is correct. And they need to ensure that they understand, because, I mean, I don't know how you feel, but I can see 20 different sets of legislation applying to the rental arena. A lot of it is never even used. But I just feel that a lot of rental agents say, right, I'm procuring a tenant, I'm taking my 8%, I'm out of here. Or I'm placing them, I'm going to manage the property, I earn my 10% every month, and I will pay over the amounts the landlord tells me to. Not realizing the obligations, particularly in a sectional title complex, is these are the conduct rules. Make sure you understand that it's part of the lease agreement. Look after the property, etc., etc. So, yeah, tenant defaults, robust landlords, and in essence, rental agents who are not fully apprised of the law and compromise their landlords, the tenants, and the complex if it's in a sectional title scheme.
Thank you for that succinct summary. Definitely will bear that in mind. Something else which is top of mind for many people living in sectional title complexes, Airbnbs, short-term rentals, short-term letting. And I know, I was in Sydney a couple of years ago, and this was huge on their agenda. And you spoke to 7 different lawyers, and they all had 7 different opinions on Airbnbs. How do you get involved with the Airbnbs if you do?
Well, I mean, when it comes to Airbnb, you just got to ask yourself the question, is it allowed or is it not allowed in a complex? The problem with Airbnbs is that if the trustees, if the body corporate decides to implement Airbnb, in other words, they decide not to extricate it by virtue of a special resolution and whatnot, they are basically, or the majority of the actual owners are making a decision that they are going to forego potential or endure potential issues to earn more income. I've got issues with Airbnb for the simple reason that there's a turnover of potential tenants. The common areas could be abused a bit more, noise, security, there's a lot of issues. Many people speculate and buy in a sectional title complex because they're allowed short-term letting, and they can score on income until, of course, the rules are changed. So I think if a sectional title, if the Airbnb tenant or a short-term letting tenant is vetted correctly, then of course it becomes a different animal, and it's something that can be quite fruitful. So, you know, I just think also, besides the zoning regulations, I think it can be managed correctly. The big problem, however, is the evictions, because it's a very anomalous situation where evicting a non-paying tenant, Rental Housing Act, PI Act, evicting an Airbnb occupant, well, do you bring a positive interdict out of the High Court? Is it a dwelling? Do you bring the PI Act? Is it a commercial eviction? If it's a commercial enterprise, it's all factual based. So I'm just saying it could be short-term gain, long-term loss.
Yeah, definitely, definitely. And then Gordon had a question about whether or not the body corporate could stop these kind of short-term rentals. And the answer at the moment, Gordon, is yes. With a special resolution, you can amend the rules to prohibit short-term letting. Absolutely. And quite interestingly, I was reading an article the other day about Florence. The city of Florence has banned Airbnbs. Our tourism department has yet to come back to us with exactly what their regulations will be on Airbnbs. Last thing that I wanted to chat to you about, and I know it's something close to your heart. You're also the director of JKS Attorneys. Would you like to just tell us a little bit about that?
Of course. Thank you so much. So about a year ago, just over a year ago, we opened up another law firm, our sister law firm, which runs from the same office called JKS Attorneys. And my two senior associates, Zenith Jagels and Sydney Kumar, are my co-directors at JKS. And it's close to my heart because it's a BE level 2 law firm, and I'm very mindful of marginalization and affirmative action. And I've never gone for this, well, I'm going to try and become BE compliant in order to get government work. You know, I've run for 18 years and I've got private clients, and I wasn't up for this tokenism nonsense, because unfortunately a few law firms go that route. So we opened up a brand new entity, and we are privileged to, within the first 6 months, to have secured a multi-million rand contract through the city of Cape Town with some other big law firms. And we are currently doing really great work in the procurement industry and with other massive players. And the beauty is that through JKS, we're able to offer a very different avenue where the rates are far less because it's a startup. By being BE level 2, we're able to offer those institutions who need it for their scorecard, and effectively getting me and my two colleagues and I, through the same excellence, but at a low price. So it's a real no-brainer. And we feel we're giving back to the community as well through doing that. So we've got a couple of social initiatives going on, and we're very excited about that. So JKS is amazing, and I'm happy to share the directorship and be a co-director with Zenith and Sydney, who've been my attorneys at Marlon Shevelew for over 8 years. So that's JKS Attorneys, Jagels, Kimar, Shivan.
That's fantastic. Congratulations. Really good initiative. And obviously at Women here in Sectional Title, we are hugely encouraging of any initiative which helps with transformation in a proper, as you say, proper way. Also, I think, you know, attorneys these days need to be specialists. I felt that for a very long time. I mean, you go to any law firm in England and you ask for somebody who deals with commercial surety. There's one person in the firm that actually deals with that, you know. And I think if you can get good at your craft and you do well in what you specialize in. So that also applies to rental agents, managing agents, portfolio managers. I think there's a big responsibility on all of us to honestly know as much as we can about the industries, to bring integrity into whatever industry we deal with. And Marlon, I'd like to thank you so very much for your insights. I know that you're always a phone call away for me if I've got any questions about rental issues, and I appreciate that so much. Yeah, let's see what next time on Women in Sectional Title, we'll be unpacking solar in sectional title and all these complexes, and really, really getting to grips with exactly what authorities needed when. So thank you again, and have a wonderful, wonderful rest of the day. And until we see you again, thank you, Wisters. Bye-bye, Marlon.
Thanks, everybody. Take care.
Take care. Bye-bye.